Well, we're here today for another discussion on litigation in our little virtual lectures. One of the things that we want to cover today is the Rule 36, and this is like my least favorite rule, and that is what we call request for admissions. Now, I say it's my least favorite rule because over the years, time and time again, it's been used as a gotcha game. Gotcha. And what you guys know what a gotcha game is. It's some young lawyer is trying to take advantage unfairly of some poor bumpkin in some small county somewhere. And so I really don't agree with this rule. I think it ought to be reworked. It ought to be different. And so basically what it means, request for admission, means that you have to admit or deny that a certain fact is true. So the questions are couched into terms that you either admit or deny the question. So let us say that a plaintiff brings a lawsuit in a car wreck case, and the opposing attorney, some young hotshot, files a request for admission that says, admit or deny that this car accident is totally the plaintiff's fault. Okay? And so basically you have 30 days to admit or deny that. And sometimes that can sound like a lot of time, but it can be a problematic issue for some guys that, let's say, they're over-the-road truck drivers. It's tough for them to get in there within 30 days. And so you can ask for additional time to respond, but it's usually problematic because they'll object. And if you do not respond in a timely manner, then, and this is the gotcha part, then the question is deemed admitted. Deemed admitted. So what do we, someone asks the question, well, this accident was totally the plaintiff's fault, and you fail to answer in a timely manner, it's deemed admitted. What's that mean? The case is over. They can actually get you bent over like that, where they could claim, well, there's no case here because he's already admitted that it was his fault just because he had a complication, something came up, he wasn't able to respond in a timely manner. So that's where I've seen it time after time. It's just so unfair and problematic, and I just don't, agree with it whatsoever. And then the other part of it is that if it is denied, then sometimes it is, well, they're objecting because the question is unclear, and maybe based on the way they're interpreting the question, they're denying it when they really should be admitting it. To me, the whole thing is just a kind of a circus and a kind of a game. I just don't see it, as being a worthwhile exercise, especially with the court's time. Everybody is, going back and forth on this, and it's really not a very pleasant thing to be involved with. Well, basically, if there is an admission, then this can conclusively establish a certain fact. Now, if it's a fact that goes to the nature of the lawsuit, like I said, it could result in a dismissal under Rule 12b-6. It can involve an amendment. You may need to amend the case under Rule 16e. So there's a number of different things that can come up. And here again, this is another rule that goes way back, clear back to 1937, and then amended in 46. And also 1948. So this can be problematic. It's pretty much the same whether it's in state or federal court. And so these are the kind of issues. Well, here once again, if you're involved in the extra credit part of this and you want to get some extra credit, you may just write like a short answer to Rule 36 what's my objections to request for admissions? What did I say was wrong with it? And it's basically the one word answer. It's a gotcha game, so I don't like those kind of situations. You're not really resolving the case like you should, but yet there's this judicial efficiency model that they want today, and so it can be an issue. When we look at this, you want to look at could be a request for admission pertaining to electronic stored information again. So basically you want to be very careful on that, that basically you can use basically the two rules in tandem. So if you use a request for production first and you get the document, and then you prepare requests for admissions that pertain to the document, maybe wages, maybe medical bills. You might have, let's say you get a medical bill and someone gives you a medical bill that's got a bunch of bills on there, but it doesn't pertain to the accident, the car accident. Maybe the person had a broken leg, and there's all this stuff in here for broken arm or something, and you find out that the person broke their arm on a different day than they broke their leg. So this is where a request for admission could be helpful, because you could exclude, do you admit that the bills that are contained in your medical bills for the broken arm have no bearing or were not part of the car accident case that is the subject of this lawsuit? Now, when it's used for something like that, it obviously can be helpful, it can be useful, but all too often it is just that same old gotcha game where they're trying to get your case dismissed out from under you because you failed to answer the request for admission in a timely manner. So hey, here once again, hopefully that was helpful about how these requests for admissions work in real life and real life scenarios that I've seen with them where it's just a big pain. So that's it for this section, litigation. Always remember, you can contact me, robdawalt@me.com. Been a pleasure working with you on this again today. Feel free to contact me if you have any questions, and we'll see you next time with something else.